My name is Carl Royal. I'm a retired attorney and co-chair of the Chicago Council of Lawyers Civil Liberties Committee. I wrote an article recently about how Chicago lawyers and judges took action against the Trump administration's improper and unconstitutional treatment of detainees and protesters, and there's a link to that you can hit to get the full story. Basically, what happened was, as you know, Operation Midway Blitz started in September of this year, and ICE and the Border Patrol swept up brown-skinned people on the streets of Chicago and nearby suburbs and put them into a detention center for future deportation. They did this in a very violent way. They broke open people's windows in their cars. They dragged people out. There was one example of a woman who was dragged out of a daycare center where she worked. All this happened, and then they were put into a detention center that ICE had in Broadview. This facility was not intended for overnight detention. It was intended for just processing for a few hours. But they had so many people that they brought in, it became overcrowded. And people there were forced to stay there for several days. They had no toiletries, they had no change of clothes, they had no privacy, they had no bedding. They were forced to sleep on concrete floors next to open toilets. It was a mess, and they also had very limited access to their families and to their attorneys. Fortunately, some of them were able to contact some public interest attorneys at organizations and at some small law firms, and those attorneys filed a class action lawsuit in federal court. That case was brought to Judge Gettleman. He heard testimony from the people who had lived through the detention at that detention center, and he found that the conditions there were unconscionable and that they needed to be changed. And he granted a temporary restraining order that required ICE to improve conditions there, to reduce the number of people in the cell, to provide fresh food and water, to provide bedding, and in general to bring the facility up to constitutional standards. So that was one victory that occurred earlier this month. At the same time, there were many protests going on outside the facility in Broadview, and the ICE and Border Patrol people there responded again with violence. They used tear gas and pepper shots, and indeed there's one example of a pastor who was kneeling in front of the facility in prayer who got shot in the face with a pepper shot. Again, public interest attorneys became aware of the situation, and another class action lawsuit was filed, this time before Judge Ellis, by a group that consisted of protesters, journalists, and clergy. This lawsuit alleged violations of their First and Fifth Amendment rights, and again, there was a hearing with testimony. Witnesses described the tactics that the ICE and Border Patrol agents used against them. After the hearing, the judge found that constitutional standards had been violated and granted a preliminary injunction to require ICE and other government agents to restrain themselves from using those tactics, to only use tear gas after giving 2 verbal warnings, and to not use more force than necessary against protesters. Again, this occurred just a couple weeks ago. So these are 2 examples of cases where attorneys in Chicago, representing the public interest, were able to put a halt to some of the practices of the Trump administration against detainees and protesters. We think that this is an example that should be followed by all of us, and we urge all members of the Chicago Council of Lawyers and attorneys elsewhere throughout the nation to use that example to take similar action when the opportunity arises, when unlawful actions occur before you. To see the article, look at the link, and for more information about the Council of Lawyers, you can go to our website at chicagocouncil.org.